So starting chapter 13, we will talk about intellectual property. And the most important things I want you to be able to capture from chapter 13 is to differentiate, is to contrast the several types of intellectual property. So let's say intellectual property is is the main branch, is the main pillar, and then there are several arms in terms of the several intellectual property types, such as um, copyright, patent, trademark, industrial design, etc. So the most important thing I want you to capture tonight is how to differentiate those, differentiate one from the others, because they're not the same. And by the way, actually each type of intellectual property will protect different things. So we want to know what those protections are and the different types of things that may be protected by each type of intellectual property. So, as I said initially, intellectual property is a type of personal property, and it is a type of actually personal property that is not tangible, it is intangible, meaning we cannot touch. And this type of personal property refers to ideas, information, and also creations, creative works. So that's what intellectual property is. And the purpose of having this system, this legal system for intellectual property, is that in one side, it helps protect what is created by mankind. So whoever creates, whoever comes up with products of their mental efforts may be protected. So society is motivated to come up with creations because they may have protection. And also, by having your creation protected, um, it is more likely that you will be encouraged to allow this free flow of your creations. So, a very hot topic nowadays, a very important and relevant topic nowadays is the search for either the cure of COVID-19 or a vaccine. So, we'll see that any of those, they may be protected by patent. So, patent law is the one that will protect the invention of a vaccine or a drug, a medicine that may cure or treat more successfully COVID-19. And the creators, the inventors, they may seek patent protection. So all the money they are investing to try finding those creations or inventions, they may be protected, and once protected, it should be available to everyone virtually worldwide. So that's the main purpose of intellectual property. In Canada, and I would say in most other countries, but specifically in Canada, all types of intellectual property, they are governed by federal legislation. So there are no provincial laws related to intellectual property. So now we need to look at those five types, main five types, but I'll be actually emphasizing and focusing on the four first types, which are copyright, patents, trademarks, and industrial design. I'll just mention very briefly to you, or just exemplify what integrated circuit topography is, but we'll be focusing on the other four types. And again, first thing, you need to know there are several types of intellectual property. So that's number one. And number two, what each type of intellectual property protects. What is protected under each type? This is um, one of the most important things in this chapter. And then we'll see remedies, we'll see details, etc. But we have to be able to differentiate. When you create something, when you find something, when you invent something, how do you protect this? So if you are inventing, creating a vaccine, as I exemplified, you seek patent protection. But if you draft a book, if you take a picture, if you shoot a movie, protection will be under copyright, for example. If you have a logo, if you have a name, McDonald's, Tim Hortons, you will have trademark protection. So again, we'll go into details, but that's very important. What each type of IP is the acronym for intellectual property. So what each type of IP protects. And let's start with copyright. So copyright will protect all those types of works, literary works. So any articles you write, any postings you make, books, even computer software. Well, after all, a computer software is a set of instructions so that the computer works in a certain way. Movies, videos, television, musical compositions, paintings, drawings, performances, sound recordings, even communication signals. So those are all examples of what copyright may protect. You don't need to memorize this, but you need to know, you need to have an idea of what copyright protects. So keep some examples in your mind. And what is copyright? Well, copyright is the work itself that will be protected. So when I say the work itself that is protected, I'm saying that it is the article itself, once available in a physical format, is protected. It is the book itself that is protected. It is not the idea behind the book, not the idea behind the movie. It is the movie itself. It is the book itself. So the case law report you wrote, it is protected. But not the idea when you thought about it. It is the case law report itself. After you wrote it, after you drafted it, it is protected. And how long is this protection for? The protection is valid for 50 years after the author's death. So after the author dies, their estate, their heirs, they still enjoy protection for the work for up to 50 years. So that's why Disney characters, for example, they are still protected under copyright. And actually in the United States, it is 70 years. So validity, the length of validity in the US is longer. But here in Canada, 50 years after the author dies. Okay? So we already know what copyright covers, how it covers or protects. It covers the actual work, not the idea behind it. So when you post a picture you took, and you don't need to post, but let's say you posted on Instagram, on Facebook, or any other social media, it is protected. That photo is protected to you. Okay? And you have such protection for 50 years after you die. So that's why it is illegal to share files. If you have the authorization to keep the file, to download the file, to have the file with you, it doesn't mean you have the authorization to share it. And it's been very, very difficult for copyright owners to control this. But with the help of investigators, with internet tools, some copyright owners have been able to track and trace people who have been illegally sharing copyrighted files. Okay, could be for songs, could be for videos, could be for photos, anything else. Okay, so that's important. And file sharing without the author's authorization is um, is illegal and may have criminal and civil consequences. So how is copyright protected? Copyright protection is automatic, not only in Canada but in most countries. And when I say automatic, I'm saying it does not require registration. It does not require application for the protection. So in other words, again, once you took the picture, that picture is automatically protected for you. Once you wrote a book, once you wrote the computer software, they are protected. No registration is required. But you can still register if you want. And why would you register? Well, you would register for two main things. First of all, there are international conventions that say your copyright, your registered copyright in your country is also protected here in our country. So if you want to have protection, international protection for your copyright, you may want to register. So you use those international conventions. A second reason you would want to register a copyright is that because it is automatic, it may be difficult to prove you were the one that created. You are the owner. So you may want to register so that there is an official governmental record. The Copyright Office, they will send you a record that your copyright is now duly registered. So those are two reasons you would want to register a copyright. But you don't need to. As long as you created a book, you created a video, you made a song, you broadcasted something, it is automatically protected. In terms of ownership, who owns the copyright in an employment relationship? So let's say you work for an IT company, you work for a creative design company, or any other types of work in which copyright may be created. If the employment agreement is silent, copyright is owned by the employer because you would be using the employer's resources, and also because you would be paid a wage, a salary to create those. So if it is the case, you want to keep ownership of whatever creations you make in an employment relationship, make sure this is clearly drafted, this is clearly prescribed in your employment agreement. Okay? We already discussed this ownership. I just want to touch upon here on the moral rights. Owners of copyright, they actually own two types of rights. They own the economic rights and the moral rights. So economic rights are those related to making money out of your copyright, And moral rights are related to your name being associated to that work, your reputation, credibility. So you can transfer when you sell, when you assign copyright to someone else. Let's say you wrote a book and the publisher now wants to buy to have your copyright assigned to them. So you may transfer both rights or only one of the rights. In most cases, writers, they will assign only the economic rights, but they will keep moral rights with them so that in case they face any threats to their names being associated with the work or reputation, credibility, they can sue, they can seek remedies. Okay, so there are two types of rights related to a copyright. In 2012, there were some amendments to the Copyright Act in Canada, and most importantly, it became illegal to circumvent digital locks. So I don't understand much about music files, but I know that Apple Music files, they only work with Apple Music or the other app or software, I forgot the name now, because they have a digital lock. So you have to pay a subscription, etc. But if you find a way to circumvent, to break those digital locks, it is illegal. And you may face, again, both civil and criminal consequences. Another aspect that was important to this amendment is that the internet service providers, also known as ISPs, they are now required to inform um, subscribers or infringers, violators of the violation they made, and they also have to provide to the copyright owner the user's, the violator's identity and contact details. So I've seen this already here in Canada. I've been living here for 5 years now, and I've seen one notification. So this person got a TELUS notification informing they had violated, they have watched a movie illegally. And how did they find it out? Well, in this specific one, I made a research and I learned that there's a company in Montreal. They investigate people who illegally have access to copyright content, and then they inform the copyright holder owner, and the copyright holder owner, they get in touch with the internet service provider. In this case, it was TELUS, and then TELUS sent a notification to this person. And this notification was a settlement proposal, and the person would have to pay, I think, up to about $200, if I'm not mistaken. And if payment were made, they would not move the issue further. They would not pursue civil or criminal actions. I don't know if they would actually do this if payment were not made, but that was basically what the notice said. And this company based in Montreal, they have access to your IP, and then your IP tells who the subscriber of internet is. So here, as a personal concern or recommendation of personal level to you, if you are the subscriber of internet service, and then your neighbor, let's say someone from the basement, from the upper level, wants to share the internet with you, there are two important things here. First of all, as per TELUS internet service contract, I'm a TELUS subscriber, so I know their contract. I've read a little bit already. We are not allowed to share internet connection, so there's a prohibition in the contract. But second of all, and most importantly, if you happen to share and your neighbor acts illegally through the internet, because you are the subscriber, you may face consequences, negative consequences for this. So be cautious about sharing, co-paying for internet connections if you don't know the person, because being a subscriber, you would be liable for this. Okay. There's an exception. Well, there are several exceptions, but one of the most important one is the fair dealing exception. So fair dealing is a concept that allows us to use copyrighted content, copyrighted material in a fair way. So if we want to use parts of a textbook, parts of a song for education purpose or for parody or satire or for research, your private study, you used textbook content for your case law report, for example, and you did not need to ask authorization for the publisher or the author. Why? Because you used in a fair way. So you just use this to complete an assignment. So whenever we use copyrighted work under those conditions, we are in the exception of fair dealing. Okay? But we cannot forget to cite, to properly cite, because this way we avoid plagiarism. Okay? We avoid um, telling others or the audience that we are the owner of that idea, of that text, in which case we are not. Okay, but we can use. That's why, let's say, when you go for a master's degree, when you go for a PhD, and you have to come up with this thesis, which is going to be 50 pages long, 100 pages long, and you have consulted, checked on over 50 books, 100 books, you can use everything you are researching as long as you properly cite. And you don't need to have the author's authorization because it's going to be um, for the purpose of education, research, study. So you can use this. Okay. And you also have to take into consideration that you are not using too much content. Because if you're using, let's say, 30, 50% of a book, then this is different. Then this is too much. What you were using, let's say you use 1, 2, 5% in different parts of your material, then this would be fine. Okay, so you also have to be cautious with this regard. And what is to violate copyright? To violate copyright, or technically speaking, we can also say infringe. So copyright infringement would be to benefit from either sale, distribution, or any other commercial use. So again, let's say you get your textbook and you find a way to make PDF files of the textbook, and then you sell for a cheaper price, or you even give it for free. So the publisher is not being paid on those free copies. This would be a copyright infringement. Okay, and there will be then remedies. All remedies we have discussed already, and I will show you some more remedies. And here it's important to emphasize and remind you that employers, they are vicariously liable for their employees' wrongdoings. You already know this. We have discussed this more than once. And this also applies for intellectual property. So in my case, the laptop computer I have belongs to BCAT. So in case I use this laptop to have access to illegal content, BCAT would be vicariously liable. So that's why employers usually monitor their employees' activities online. Okay. Some other exceptions that we can use, we would not be infringing, is when we are copying legislation or case law. You also did this in your case law report, or some of you, I haven't read them yet. And you can also use, as I said, quotations, as long as they are not too extensive. Then you would be under the fair dealing, you would be under the exception. So remedies, let's say you are a copyright owner, holder, and you find out someone has been violating, infringing on your rights, getting money, or even distributing for free something you should be paid for. So remember we discussed about injunction as an order. What is injunction? Injunction is in stop order. So stop doing what you're doing. Stop violating my right. So as an owner, you would go to court and seek for an injunction. And here, you could also seek for an interlocutory injunction. And interlocutory here means interim. It is an order that comes before the trial. And why would a judge award or grant an order that comes before trial? A judge would do this because the evidence is very, very clear that an infringement is taking place. And if the copyright holder waits for the trial, it may be too long to protect their rights. So I want the infringer to stop infringing my rights right away, now. And as long as I have clear evidence to this, the judge would be very likely to grant an interlocutory order. And then there's the permanent injunction after trial. You can also get damages. And there's one new order here that is more specifically to intellectual property. This new order is called Anton Pillar order. This Anton Pillar order is an order which allows the court to seize offending material. So again, I believe you are keeping, let's say, illegal files in your laptop. If I'm suing you, when you get the civil claim, you would likely want to destroy your computer, your laptop computer, so that you would destroy the evidence. If I get an interpillar order, you wouldn't have the opportunity to destroy your laptop computer, because when you got the civil claim and this order, your laptop computer would be seized. So this is very important for intellectual property in a way to protect offending goods, offending material that would be key evidence for the trial, for that lawsuit. So this order is called Anton Pillar order, and you should know this order. You should remember and memorize this. The question here: do you have to pay to have copyright annually? Well, payment for copyright depends on who owns the copyright, who owns the economic rights. For example, your textbook, you only paid, you paid $80, $90 to have a 6 months access to the textbook. So it depends who the owner is and how much they want to charge and for how long. There are softwares, for example, you pay only once and you have it for your life, and then you have to pay some extra fees for updates on the software, or sometimes the upgrades will be free. So again, it will always depend on who owns the copyright and how they want to charge. Okay. Um, Copyright holders or owners, they can also sue service providers. So there was this case in which YouTube was sued. And why this? Because those service providers, they have tools, or they should have tools to prevent this. So in case they don't do this, they are not diligent, they may be sued by the copyright owners as well. This is just about the board. So question for you about copyright. So which one is true? Which one is right? E. Well, we actually, technically speaking, we cannot say E is wrong, but I would say I would have E as wrong because it's mostly by statute, almost 100% by statute and not common law. But things are changing. So in this case, D would be the true statement. But if this question were in an exam, I would have to accept challenging for E. So there are common law remedies, very little or common law. The rights actually they come from statute. Remedies will come from common law. So it would be debatable here. But let's go for D in this case, because D is the clear one. So copyright is owned by the employer unless there's anything in contrary in the employment agreement. Okay, is that clear? Copyright owns for lifetime. It actually more than lifetime. One of the first slides, just show it again. So it's 50 years after the author's lifetime. So 50 years after the death. Okay, so actually the state, the heirs, they will have copyright for longer. All right, so now let's move to a second type of IP. And the second type is patent. So we already know what copyright protects. Protects literary works, dramatic works, songs, music recordings, etc. Now let's look at patents. Oh, the right answer for that one is D. D as Donald. D is the right answer for this one. So what is this? What is this picture in here? Have you ever played with this? You probably have. Does anyone remember? Okay, this is Lego. So Lego, they filed for a patent back in 1958. And patents, differently from copyright, they are valid. Protection is valid for 20 years. Not 20 years after the author's death. No, 20 years after application, after you file your application. But what is a patent? What does a patent protect? Well, a patent will protect things such as Lego here, vaccines, as I said, drugs, medicines. If you have a smartphone, your smartphone will have lots of patented products. The touchscreen is one of them. By the way, last year Apple won the battle against Samsung for touchscreen patent ownership. And Samsung had to pay over $500 million to Apple. So what does patent protect then? Patent protect the physical embodiment of an idea. So you have an idea for a product, for a system, for a mechanism, then you can get protection for that. Again, as I said, touch screens, medicines, drugs, machinery, um, anything that can be uh, physically manufactured, and anything that will have a process to manufacture. So those will be protected by a patent. Okay? And for someone, for an invention to be able to be protected, this invention has to be new. No one can already have a patent for it. This invention has to be an original work. It also has to be unique, distinguishable from others. It has to be useful because it has no applicability, um, if it's not for good use, then it can be patented. And also, it has to be possible to be built. It has to be possible to be manufactured. Those things may be patented. So um, imagine how much money companies are investing. Even governments are now helping companies, bio companies, to try to find vaccines for COVID-19, or even to find how they call, um, well, there are some scientific names I don't remember now, but to find chemicals that would be good and efficient for COVID-19. So all this money, they may be captured back. They may return to the inventor because they will have protection. And this protection says that the owner, the inventor, has exclusive rights over their invention. Others will be able to use only if they pay fees to the patent owner. Okay? There are some things that cannot be patented. The law says those things cannot be patented, such as theories. So let's say physics theories. Those cannot be patented. Or even mathematical theories or any other subject theories. Those cannot be patented. Or obvious improvements of current products. And what is obvious or not, this will be decided by the patent office. So those things cannot be patented. Even computer programs, so computer software, as we discussed before, they are protected by software. Here, I just want to point out that there are some countries that are now allowing computer programs to be patented. But this is something new. This is something that has been developed for the last 10, 15 years. It is not so clear yet. So I just want to mention this, but you shouldn't worry about computer programs in terms of patents. Let's just remember that computer software in Canada is protected by copyright, not patent. And here in Canada now, after the Amazon case, business methods, they may be patented. And the Amazon case, let me tell you, the Amazon case was Amazon patented their one-click purchase. This one-click purchase is an example of a business method. And they had it patented in the US. So they also tried to patent here in Canada. And that patent was not granted by the patent office. So Amazon sued the patent office, seeking patent protection for their business method, and the court ultimately found that yes, they could patent their one-click purchase business method here in Canada. So that's why now business methods may be patented in Canada. Okay? So I told you that copyright protection for copyright is automatic. You may want to register for the reasons I've given you, but you don't need to. For patent, it is different. For patent, once you come up with your creation, your invention, you have to apply for patent protection. And then the patent office, among other requirements, they will go through those requirements here I mentioned to you. Is this actually new? Is it true that no one has a patent for it? Is this original, unique, distinguishable, useful, etc.? And then if they understand that that application meets the requirements, then the patent will be granted. Okay? And a patent, well, all types of intellectual property, copyright, patent, trademark, etc., they are only protected in the country in which protection comes from originally. So, as the Amazon case, they applied for one-click purchase in the US and they got the patent. And then they also wanted protection in Canada, so they had to apply here in Canada. So you may be wondering, well, if I want protection worldwide, over 200 countries in the world, do I have to apply for a patent in all those countries? The answer is yes, you do. So it requires a lot of money. There are international conventions that make this application in different countries smoother, easier, but still you will need to apply in each and every country. So in terms of copyright, I told you you don't need to. The conventions for the international conventions for copyright, they say that if you have a registered copyright in your own country, other countries that have signed that convention, they also give you protection. But for patent is different. For patent, the conventions, they make application in other countries easier, but you still have to apply in other countries. And it may be the case that one country will grant you the patent, the other will not, such as it was the case for Amazon. They finally got it because they sued, but still, patent offices from US and from Canada, they analyzed the business method and each country's domestic legislation in a different way. Okay, so that is also important. Again, protection will be valid for 20 years. Okay, so you have a monopoly of 20 years. That's why companies invest 50 million, 100 million. Now they may be investing near $1 billion to try to find COVID-19 vaccine or drugs. And with the monopoly for 20 years, hopefully they can make much more money than their investment. That's why one of the reasons for patent protection. So that's patent. Question for you now. Yes, the right answer is C. So there were those requirements to have a patent granted, and this one that the invention was not known or used by anyone before the invention. So this is one of the requirements. Right. Are we good? Any questions here with any other options? All right, so let's look at the other type of intellectual property, which is now trademarks. Again, we started this chapter looking at copyright. We just looked at patent, and now you know they protect different things. And now we'll see trademark that protects other things. So what does trademark law protect? It protects terms, symbols, designs, even sounds or colors. Harley Davidson motorcycle, their sound is protected by by trademark in the US. Tim Hortons, we have the logo here. So this logo, this design is protected by copyright, by trademark, sorry. So this protection is intended to protect consumers from being deceived, from being fooled. So if I know you like Tim Hortons and I come to you with a cup of coffee from Starbucks, you already know you don't like it, for example. So the cup colors, the logo from Starbucks, they inform you that it is not Tim Hortons, the one you like, for example. And protection for trademarks. They used to be, by the way, the textbook is saying 15 years, 1-5, but there was an amendment in the Trademark Act last year, June last year, and now protection is for 10 years. So if you ever have a question in your final exam for the period of validity of a trademark, I expect you to remember it is now 10 years, not the 15 years from your textbook. Okay? But the good thing here is that trademarks, they may be renewed indefinitely. I have not mentioned anything about renewing for copyright or patent. In other words, there are no renewals for copyright or patents. But for trademarks, yes, it is possible to renew trademark protection. And it is possible to renew forever. So even though, let's say, Disney will lose, they may lose their copyrights under the Disney characters, the name Disney still belongs to them. The logo still belongs to them because they are renewing it indefinitely. Okay? Again, Apple owns the patent for touchscreen, so they have the monopoly for up to 20 years. But the logo they use in the iPhone is theirs for good, as long as they keep on renewing it. If you fail to renew, if you forget to renew, then you may lose it. Okay? So that's the characteristic for trademarks. Trademark law is also used for domain name disputes. Let's say I am smart enough and I create a domain name that is available and I say applelaptops.ca. So if I start selling goods that are not originally licensed by Apple, I'm actually trying to capture Apple clients and to deceive them. So Apple could sue me to get this domain to them because they are the owners of the Apple trademark. This is new for the last, let's say, 20 yeah, 10, 20 years. But now it's very settled already. If you ever have issues with domain names, if you are the owner of the trademark, you are most likely to get that domain name transferred to you. So the remedies for infringements, they are the same as copyright. We already discussed those remedies: injunctions, damages, even the anti-pillar order. And you may lose your trademark if you abandon it, if you are not active in business. So let's say you came up with a business idea and then you created your logo, you registered your logo because trademarks, they have to be registered. Protection is not automatic. Then you register, you started your business, but after 3 years, you found that your business is not going to be successful. So you stop doing business. That trademark is technically protected for you. But because you are out of business now, it means you have abandoned it. So you lose protection for abandoned trademarks. Passing off. You saw this tort in chapter 4, torts that are related to business, impacting businesses. So here, why does this tort exist? Well, first of all, if you have a registered trademark and someone is using your trademark without your authorization or without paying the proper fees, etc., you may sue them under the Copyright Act for trademark infringement. However, if you have a name, if you have a brand name, you have not registered it as a trademark, but that name is famous. Consumers recognize your business for that name. But because it is not a trademark, you cannot sue them under the Trademark Act. So you would sue the infringer for the passing off tort. Passing off tort would then be useful for brands, names that are famous, that are relevant in business, and are being used by others without the owner's authorization, and that are not registered as a trademark. Okay? Then you use the tort for passing off. Question here. Is domain name like a trademark that you have to register and renew? I cannot say it's like. The system is different. But well, it is similar. Not like, but similar. The thing is, registering a domain name is easier. You can do online now. You can just go to any domain name service providers. You come up with a name, and here in Canada, as long as you are a resident here, and I don't mean permanent resident, I mean you are legally resident here, even with a study permit or work permit or any other types of immigration status. And as long as the domain name is available, you just pay a fee and you register it. And yes, you can register it for 1 year, for usually you register for 1 year, and then they offer you to pay for 1 year increment protection. So some companies, they offer you to pay for only 1 year, or you can pay with some discount for 2 years, for 3, for 5, for 10. And yes, you have to keep on paying the renewal. Then you keep the domain name to yourself. So it's similar. It is different legally speaking, but the system is similar. What happens when a new company wants your domain name that you own? Well, if it is a new company and they don't have the trademark that is related to your domain name, well, they don't have a right to your domain name. So you may sell it to them if you want, or you may want to give them for free. However, if you have a domain name that is related to a registered trademark or even to a brand that was famous before you registered that domain name, then this company may be able to have your domain name transferred to them. But this would be a dispute. You would have the company would have not to sue you is actually could be suing in federal courts here in Canada, but there are a lot of mediation and arbitration services for domain names, and they are very, very effective. The World Intellectual Property Organization, WIPO, based in Geneva, Switzerland, they have a very efficient and famous mediation and arbitration uh, services for domain names and also dispute settlement mechanisms. Okay. All right. So, question to you about trademarks. And I'm sorry, I know we're going a bit long, but there are a lot of details for this chapter, so we have to go a bit longer. Okay, I had not updated this question, so I have to update it. Sorry. Yeah, B would be the false one, but there's another one. So B should be the correct, should not be false because it used to be 15 years. So that's why I corrected now. Sorry. It is not B. It is another one. Not E. E, there's the presumption is true. Yes, C is the wrong one. Because C is saying that if a person registers a trademark but then abandons, fails to use, the protection will not be lost. This is false. This is not true. If you abandon, if you fail to use, you will lose protection. Okay? So C is the right answer because C is the false statement. And sorry here, I had not corrected the question before. So that's why you chose B initially. But the correct answer is C. Okay. All right, so let's move on. I don't think it's going to take too long from now on. So the other type of intellectual property is industrial design. And industrial design will protect the unique shape and pattern of an article, of an item. So this bicycle here, it is not the bicycle itself, but it is the design of the bicycle, the shape, um, the unique shape and pattern. Protection here is for maximum 10 years. It is actually 5, and then you can renew once only. So you register and you have 5-year protection, and you may decide to renew, but you can renew only once. Trademark, we just saw, you can renew indefinitely after every 10 years. Here for industrial design, no, you can only renew once. That's why I'm telling you protection is maximum 10 years, as long as you had renewed after the first 5 years. Okay, so that's industrial design, briefly speaking. Integrated circuit topography. I won't focus on this, just for you to know what it is. An example is will be the 3D microchips that are in computer motherboards. So those are integrated circuit topography, but I won't be focusing on them. So now looking at confidential information. Confidential information, what is this? Is any type of information in which intention or that is intended to remain confidential, that is intended not to be disclosed. And here, the confidential information, when you have confidential information, it doesn't mean you own that information. No, no one owns information. The issue here with confidential information is actually the duty not to disclose, the duty to remain confidential, to remain in secret. Okay? Because if it is ever disclosed, it may cause harm to someone who trusted you to share that confidential information. And this confidential information could also bring benefits to someone who had access without having authorization to. So that's the issue with confidential information. And this is very, very common nowadays, or I would say for the last 10, 20 years, because we are living in this information age in which companies, they have competitive edges because they have confidential information with them, and they use them, the confidential information, for their best benefit. So it's very common in business nowadays for companies, when they start negotiating, when they start um, interacting with one another, they sign non-disclosure agreements. So agreements in which both parties, usually both parties, but it may be only one party, they agree not to disclose confidential information they have access. Okay? And for us to protect confidential information, we need to identify the information as confidential. So you can use a watermark, you can use a footnote, you can use a tag, a flag, but you have to use something. You have to write confidential information so that the receiver knows they cannot disclose. That confidential has to remain um, confident, confidential. And one of the most important types of confidential information is known as trade secret. So I'll tell you, in my view, two of the most important trade secrets in the world, they are Coke, uh, um, the soft drink, so Coke, Cola, the formula, and also the what is that? The sauce for KFC, KFC sauce. So those, the manufacturing process, the ingredients, they are kept, not the ingredients, but the manufacturing process, the secrets, they are kept as secret. Imagine if back in the early 19th century, if Coke had applied for a patent for Coke. After 20 years, that patent would be expired and anyone would be able to use. Maybe Pepsi wouldn't exist because Pepsi, I would say, and this is a joke here, but I would say Pepsi is an attempt to duplicate or to imitate Coke. And by the way, I'm a Coke addict. I don't like Pepsi much. But still, Coke, they were able to keep their formula as a secret for over 100 years now, and it's still a secret. And what is the advantage of a trade secret? Well, you can keep it forever, as long as you are able to keep it as a secret. Because if intentionally or even unintentionally your secret is revealed, you lose your competitive advantage. Okay? And again, companies or people, they do not own the trade secret or the confidential information. They use it because they keep it secret. So it is only they that know that information. So they use it for their advantage. But in case it is revealed, they will have to use contract law remedies. But the information will then be revealed, and they cannot claim any proprietary rights in the information. Okay, so that's what I wanted to share about confidential information, and the main type here being trade secret. As I said, if the confidential information or trade secret is ever revealed, you would then try to seek an injunction, damages, and any other remedies that are available. Okay, so now just want to finish with private information, how private information is protected. In Canada, it is protected by both federal and provincial legislation. And companies, they have to have privacy policies if they collect private information. By the way, when you call MSP, if you have ever called, because they collect personal information for identity purposes. So they say if you keep online to speak with a representative, you consent to the collection of personal information for identity purposes. So by uh, disclosing this statement, they are actually telling you their purpose of collecting your information, and they are actually asking for your consent. Those are two requirements for companies that collect private information, personal information. They also have to keep information secure, and if there is any breach in their systems, any hacking, do you remember the last hacking situation we faced here in Canada for personal information, private information? There was this health company that suffered a breach in their systems. It is Life Labs. Life Labs had, I think, over, well, if I'm not mistaken, over 500,000 clients of Life Labs had their personal information stolen. So whenever this breach in their security system takes place, they have to keep a record of this breach, and they also have to inform the government of the extent of the breach. Yeah, possibly Facebook already had this. There is this relationship website, Medicine something. They also had this some years ago. Before Life Labs, there was another company, Equifax. I think Equifax. They also had this, if I'm not mistaken. So protecting private information and personal information is very important nowadays. Privacy legislation is very, very important, and it's a very hot topic. Just briefly talking to you about this for 1 or 2 minutes, but you could study privacy law for over a term or for over a year. You could have any specialization only on privacy law because it's very, very important and a very hot topic. Okay, I think that's mostly what I wanted to share to you. So remember, in terms of IP, intellectual property, it is very important to understand that there are different types of IP: copyright, trademarks, patents, industrial designs. You should know what they protect. You should know for how long the protection exists. Only trademarks can be renewable forever or indefinitely. Industrial designs can be renewed only once. Okay? So that's IP. I found it very interesting. I find this topic very interesting, and sorry I went long. But I hope you have enjoyed the topic.